Minister Marsh-Smith. Colleagues, we were on page 10. And
Still, before you go.
Sure. Go ahead.
John?
Yes, go ahead.
Tendering an apology on behalf of Member Charles Sinclair.
Okay.
Yes. He's on the route to court and is not able to connect.
Okay, all right, no problem. The Minister Johnson Smith said she will try to join us, but she can't stay with us for too long too. So she will try to join and then stay for a short while. All right. No other apologies, Anila?
No, Minister.
All right, we're going to go straight to page 10. We had completed that matter with the fingerprint. So we move at the very top at clause 12. And the main consideration there are the red marks. So we have to see if, I think basically we agree to these. Is that okay, colleagues? Or so Kamika, what were the problems? They just wanted to ensure that we accept, but in the committee accept that acceptable to include the person with disabilities ID in as a verification. Is there a problem? I mean, there's no problem in including them for verification. We just it will assist. What do you say, Kamika?
I'm gonna ask Mr.
Warren, is there a problem? I mean, will it? I mean, it's just another document for verification. Is that a problem, Warren?
I don't see any issue, Chairman. I don't see any issue at this point in time.
So we will remove the brackets in the first red sentence, and in the second one, the committee act. So because it won't really cause a problem. So remove does not accept Kamika. And remove the brackets. Are there other concerns on page 10, Kamika, that you would bring to our attention?
Not on page 10, Chair, no.
Right. In the final draft, you had removed the last matter. All right, no problem. So that's page 10. So we go to page 11. If there are no difficulties with page 10. And page 11, we have gone through clause 14 and 15 repeatedly. And therefore, if there are no concerns with page 11, we had made some changes last time. So that's page 11. If there are no difficulties, we can more or less accept. Bear in mind, on page 11, the last line, AG, you will recall that this reflects what you had indicated, AG. That clause 17.1 made clear that the national ID would be sufficient proof of the individual's identity, and the person, once they show the national ID, there will be no requirement for them to show any additional proof. So that draft, and as recommended by UAG, seems to be acceptable. So that's on page 11. We move to page 12. And these are fairly straightforward provisions. And some of the recommendations from the presenters were indeed accepted. And the content, etc., we agreed to. So that's page 12. If there are no concerns, we move to page 13. In the third paragraph on the page clause 20, that starts in relation to, hold it, in relation to leave to remain in Jamaica. What you have is to remain Jamaica, to remain in Jamaica.
Okay.
Okay. So just a slight correction there. So that is page 13. No difficulty with page 13. All right, continue.
Ms. Grant has her hand.
Yeah. Ms. Kamika,
No chair, Ms. Grant.
Ms. Judith, yes. Oh, please, if there are any bracketed sections, please notify us, CPC. Yes,
Thank
CPC.
you.
go ahead.
Chairman, there, I believe, the committee had recommended some changes. Clause 20, so that instead of the card being canceled, there would be a suspension.
That is correct.
So there were the details as to how that would operate weren't really fleshed out. So I had done a draft, but there were some issues that would have needed to be settled.
May I ask the CPC? The idea is that section 20 had indicated that the committee would cancel, but what we're saying, rather than immediate cancel, you suspend the operation of the card because the clause actually says may cancel. Isn't that so? Clause 20.
Yes, Chair, it does.
It said that the authority may cancel identification card if done so. And what we were suggesting is that rather than an immediate cancellation, that it be suspended for, it's really given time before the cancellation. How would you put it, CPC?
Right, so I could just quickly run through. The authority cancel a card under subsection 1 unless the authority by is giving the prescribed form informs the individual of the proposed cancellation and of the individual's right to appeal under section 26 against proposed cancellation. And either the time limited for bringing the appeal has elapsed without an appeal being brought, or an appeal is brought and the appeal tribunal confirms the proposed cancellation.
Right. So you'd make that.
Well, Chair, it goes on. An individual who, pursuant to subsection 2, is given notice that the authority proposes to cancel the individual's national identification card shall surrender the card to the authority within, and I need a decision as to the time which the person should surrender the card.
What time you give? What time you give, CPC?
Well, it was 30 days before in relation to cancellation.
I think that's okay. Any other suggestion, members of the committee? So, because the original position was to cancel, now we're giving 30 days before cancellation.
Yeah, I think that
It's 30 days to return.
Minister Robinson?
No, I'm fine with that because it gives the person an opportunity to address an issue if it arises before
Right.
cancellation. Okay with that.
Okay, wonderful. Thanks, Member Robinson. So that's okay, CPC.
So the individual shall surrender the card within 30 days after receiving the notification that the author proposes to cancel the card, and shall not use or permit use of the card during the suspension period.
Right. Sounds good, CPC.
Well, Chair, there's further provision now. The validity of a national identification card shall be suspended during the period, the date immediately following. I need a decision here as whether it should be the date immediately following the date of service of the notice about the proposed cancellation, or should it be the date on which the notice is actually served?
I would say from the notice is issued.
The date of the notice, all right. And depending on the date on which either of the conditions referred to in subsection 5 is fulfilled. And the conditions under subsection 5 are that either the time allowed for bringing the appeal under has elapsed without the appeal having been brought, or where the appeal is brought under section 26, a copy of the decision of the appeal tribunal has been served on the authority and the appellant. And 6, where on an appeal under section 26, the appeal tribunal confirms the proposed cancellation of a card, or the time allowed for bringing the appeal under that section has elapsed without the appeal having been brought. A, the authority shall cancel the national identification card, and B, the individual concerned shall, 1, in the case where the appeal is brought, surrender the card to the authority within 30 days after the date on which the individual is served. Well, I don't think we need this because we would have already surrendered the card.
Right.
On the
And Chair,
notice.
clause, an adjustment to clause 21?
Well, it would have to be a provision for the card to be returned if the appeal is allowed.
Right. So yeah, I'm saying
That
you're
change.
making it part of clause 20.
Right. And in the case where the appeal is not brought, surrender the card to the authority. All right, yes. So I'll change that to include a requirement for the authority to return the card if the appeal is allowed. And then
May I sorry, CPC, after you're through. I thought you were through.
Well, it would just continue with subsection 7, which provides the offense for an individual who, without reasonable excuse, contravenes subsection 3 or 6, which would now relate to not surrendering the card, or 3 or 3, not returning the card would commit an offense. So that's it.
Yes, AG.
Remind me, the card remains the property of the state, doesn't it?
It does.
In the same way that a passport does.
Yes, I think that's correct, AG.
Okay, just please remember to have that stated expressly in the law.
I think it does. Yeah.
Right, okay, right.
Can you? I recall there's somewhere it says that the ID card is the property of the state. Can you recall, say the exact location?
Looking for it, Chair, but it is stated that.
I'm almost sure it says so. Look at clause 16.9. 16.9. You see that, aging?
Yes, thank you.
Okay. All right. So thanks, CPC, for that. For the draft on the recommendation that we suspend the card rather than cancel at the beginning. So that is clause. Sorry. Page 13, we now move to page 14.
Sorry, excuse me, Chair. Good morning, Aldred. So through you to CPC. CPC, in terms of the timelines for suspension, I think there was a decision about once the notice is issued, but not served, that the card could no longer be used. What was that the decision? I know you asked about whether it should be on issue or with on service. What was that point? Because I wasn't clear.
No,
Sorry about that.
once the decision is made, then the card would not be usable. I think that's the understanding.
So even though the person is not aware,
Well, once
because you were saying it's on issue once the decision is taken and whether or not the person has been served with a notice.
No, it's suspended during the period from the date of service of the notice on and ending on the date when either the time for bringing the appeal has elapsed or where the appeal is brought, a copy of the decision is served on the individual. So that's the suspension period, and the person should not use the card during that period. So it runs from the date of service of the notice.
Oh, okay. Thank you.
Wonderful. All right. Page 14, seems any concerns, Kamika? No brackets?
No, Chair, no concerns there.
So if there are no concerns, we move to page 15.
Which,
And the concerns members of the committee or any matter to be brought to our attention, Kamika?
no, Chair.
That's page 15. Page 16. Any concerns, anyone? Okay. Page 17. No concerns and no brackets, no matter to be brought to the attention of the committee, Kamika.
No, Chair.
All right, 18.
Sorry, Chair. Yes,
sure.
there is one issue in clause 29.
That's
Section
on page
3.
16.
Yes, subsection 3, where the committee had recommended that we look at the wording for 3B, where nothing in this section or in a warrant issued under this section shall be construed as authorizing the seizure of anything if the seizure may be reasonably expected to, I think the original wording was maybe expected to have a negative impact on any aspect of Jamaica's information communication technology infrastructure.
Right,
Some members had an issue with the words have a negative impact.
right.
Right, so we're suggesting either the word disrupt or the word compromise could be used so that the provision would read, if seizure may reasonably be expected to disrupt any aspect of Jamaica's information or communication technology infrastructure. That's one option. The other option is if such seizure may be reasonably expected to compromise any aspect of Jamaica's information communication technology infrastructure.
SG, can you help us? In other words, if you would replace it for the words have a negative impact.
Right. So just like a decision whether the committee would prefer the word disrupt or the word compromise.
AG and SG, any suggestion?
My preference is for compromise.
Member Robinson, what's your opinion?
I must say I do have a strong view either way, to be frank.
All right, because
That's how we do it.
Chair, I think when we were, I think I had been one of the persons concerned about the wording.
right,
But when the explanation was given as to why this clause, what was intended to be achieved by this clause, I got the feeling that it was more disrupt that they were saying. So that when the person who gave the explanation could revisit their explanation and advise on the appropriate word. Because frankly, as I said, I formed the view that it was a disruption.
What would go wrong in using both? Compromise or disrupt? And
I would say disrupt.
uh,
That's what I'm saying. Based on their explanation, it sounded like they were anticipating a disruption.
but what would go wrong in using both? I mean,
No, I'm not. No, not. I think that both would be perfectly acceptable. I'm sorry, I didn't hear you properly, Chair. I think both would, because I think they connote different things.
CPC could be used instead of to have a negative impact on, we have expected to compromise or disrupt any aspect. Would that be acceptable to you as the draft person? CPC?
Yes, Chairman.
So instead of to have where we have 29(3)(b, where contains identity information, if such seizure may be reasonably expected, we're removing to have a negative impact on and put in place expected to compromise or disrupt any aspect of Jamaica's information. Okay? Okay, thanks for the understanding and agreement. So that was page 17. We're going to page 18.
Chair,
Yes, please.
Chair, just to point out to the committee at clause 29(3)(a, just to remind the committee that they had noted the concern that the bill does prohibit the copying of items and recommended that the subclause be amended to address both the copying and the seizure.
Yes, that's my recollection.
Yes. And Chair, if we could recommit page 15, I believe that there may be an issue there that we needed to.
Page 15.
Yes, just to ensure that it is in fact correct. I have a note on mine, but just ensuring that it was. It's 24(2)(b). It's about, just to make sure we have indicated the, no, go up a little bit further, please, the previous page.
Yeah, there.
Okay.
24. Okay, 24.
Okay, right, Chair. So that sentence does not adequately indicate what the committee actually decided. So it is suggested that it actually reads, your committee does not accept that it is necessary to defend, I'll read through. Your committee does not accept that it is necessary to defend the term national security, but recommends the insertion of further guidance to the judiciary in a similar manner as provided in the Interception of Communications Act.
That is what you would like instead of what is there.
Yes.
Because any concerns?
Excuse me, Chair, which section of the Interception of Communications Act is being used as guidance?
Gonna ask Ms. Grant if she recalls the specific section. I don't recall the specific section. I will. Let's see.
So what is the proposal you're making?
Right, so the committee had not actually agreed to redefine the term national security in a narrow manner. It had actually agreed that the term national security would not need to be defined. At first, the committee had thought or expressed the view that it adequately provided, the bill adequately provided a framework. However, thereafter, the committee had indicated that, Ms. Grant had suggested that we could utilize something akin to what is utilized in the Interception of Communications Act, and the committee had agreed with that. So it would, right.
Sorry, just to answer the SG's question, the provision section 11 of the Interception Communications Act which sets out the directions that provides for the judge to issue certain directions to ensure that to guide the extent to which the information might be disclosed and generally dealing with the handling of the information.
Okay, understood. I was also wondering if you consider then section 2.2 of the Interception of Communications Act, is it that the committee, that is in this, that the interest of national security shall be construed as including, but not limited to, the protection of Jamaica from threats of espionage, sabotage, any terrorism offense or subversion? I was
CPC,
wondering if that was considered, or if it's just to put in the
Yes,
safeguards in 11.
right, it was safeguards because the point about defining national security was not accepted. So
Okay.
so we agree to accept the recommendation then, CPC? So you,
recommendation about the directions to safeguard the handling of the information.
right,
Yes, those were incorporated.
right,
Is
so
it
The
as
wording.
in 11.1? The safeguard is all matters in 11.1 or some of them?
I think it was all of them. The provision, it was included in the version of the revised draft bill. So you could have a look at that.
that is in
I
20,
could. That would be on page 52 of the draft.
2.
It's in my draft share. If I could share the screen for a moment.
Go ahead.
No, so Brandon would need to stop sharing. So it was, oh, I'm so sorry. I passed it. Apologies.
You passed it again up to, yes, 12.
Right here,
This is
12?
subsection 12, subclause 12.
Okay, here it is. I passed it again, didn't I? I'm so sorry. Tell me, Judith, if I passed it.
We're off there now. Slow down. Go ahead.
Just go up at, right,
Here,
that's it.
right.
That's
So
it.
it starts from here,
Right.
SG.
SG, you want to just have a look at it?
Tell me when to go down.
Yes, you can go ahead.
So that is basically what. Is that okay, SG?
I'll look at it some more.
And
The,
then
the protection of LPP is in a different section though, right?
right.
Yes.
So
The
you can
protection of LPP applies to this taking of copies as well?
No, it would be in the power of search and seizure section.
Right.
Okay, so you're saying it needs to.
Because I think that what's in 29 spoke about that section.
Yeah, it is.
This is a different section.
Yeah.
No, so
No?
provision about protecting LPP was included in an adjustment to the regulation making power under clause 33, where we had added a new subclause 2N to provide.
It's no longer 29.
No, the
okay.
decision was that regulations and a form would set out the content of the directions that might be given there.
The warrant though.
1C.
But we specifically refer to 29. So if it is SG that you're saying it needs to be protected as well with regard to LPP, then I don't think that is currently done. That was not a matter that had been considered.
And certainly needs to be considered.
Right, and I think we agreed to that there should be no copying.
Right, that was with regard to a warrant, though, not in regard to, that was in regard to search and seizure, not in regard to disclosure under clause 24 following a court order.
And what's the suggestion, Tamika?
Well, we could then, following on the guidance from the Solicitor General and the agreement from Senator Scott Motley, I believe that we should indicate.
Okay, no problem.
What are we in, please?
Oh, I believe we're putting in protection of LPP for this particular section as well. So in the event of disclosure.
Is that okay, CPC? All right, so CPC and Tamika, please study it up with SG, okay?
Okay.
All right, so we can go back to pages 18 and 19. Anila? I think.
Sorry, if I may, Chair, just through you to CPC, just to indicate that I know that this is a judge driven process, but I still think it would give the guidance or direction to the judge that in making any direction or in giving his or her decision, they should ensure that breach of the LPP principle. Yes.
Right. I think that's the understanding.
Right. I just wanted to make it clear because we don't have it, so it's not explicit in Interception Act, but it's just that we have had cases since that
Yes.
making us revisit how we provide for it in law.
So we make it very clear in section 29.
That is my suggestion.
Right, okay.
29,
24.
Oh, 24, because it's already in 29.
Right.
No problem. All right.
And you're saying also in 33 to CPC. So it's throughout, Chair.
Okay, in the regulations, no problem. All right, thanks SG and CPC. So it can be cleared up. So pages 18, we're on page 18. Is that page 18 scroll? No concerns. And then pages 19, I think we have some matters to clear up on page 20 and 21. So continue.
Chair, we hadn't specifically indicated we had not specifically indicated the change that was made to clause 33 with regard to the protection of legal professional privilege via that warrant. I don't know if the committee would believe that we need to specifically indicate that change that is being suggested.
It's in the regulations and says yes, because we agree to that.
Sure, so we will insert appropriate language.
Right. So, page 20, Bob, we have take some decisions. Stop there. The committee agrees that there should be clear provision for all instances of leave of absence. Would that be in the regulations? Yes, no problem, it's the schedule, so we agree to that. Is that okay, members of the committee? It's in the schedule. Fine, that's okay. Continue this board schedule now. All right, members of the committee, just look, it seems these are recommendations that came.
Those recommendations, Chair, came from a review of the bill.
Right.
In the cancellation of the card clause,
Mhm.
one of the bases for cancellation of the card is when the Commonwealth citizen no longer has leave to remain, and where the Jamaican citizen has registered a declaration of renunciation of citizenship, but there was no corresponding change to the legislation that actually governed those regimes. So it suggested that that be inserted.
Right, so these are recommendations that the Secretariat is urging us to accept, members of the committee. Member Robinson, SG, AG, do we have any difficulty with those? In other words, the Secretariat is recommending that consequential to various changes that and discussions that we have had, that these should be consequential changes to these particular acts. And that's a recommendation of the technical team. Do we have a difficulty?
Ms. Andy has her hand raised.
Sorry.
Fine, Chairman, no issue.
All right, thanks, Member Robinson.
Objection to the recommendation.
CPC, you wanted to say something?
Yes, Chair, thank you. If you were through with this particular section, I just wanted to go back to clause 24.
So before we go back, let us
Okay.
agree then to go ahead to these, and also the registration works. And then the final one. Now, the final recommendation, we have agreed.
Excuse me, Chair, how does the, sorry, I haven't fully gone through the draft, so I know it could be captured there. Apology for my question, but just how would the Minister of National Security notify the authority? If you scroll up, right, for both, it's saying the Minister notifies or informs the authority. How is it done?
Is that something you could put in the regulations? No.
And you have said it's a requirement, so we're placing a statutory duty. I mean, I understand why, but just I want the committee members to understand what they're putting in or proposing in the law. You're placing a statutory obligation, a statutory duty on the minister to inform the authority.
Well, put it
I
in
wanted to know how it's going to be done, and just remind that you're placing a statutory duty on the minister.
okay, the point is that you agree that it should be done. The question is how.
Well, Chair, it's already in the bill in the consequential amendments. It was just that that particular situation had not been addressed. So, for instance, under the amendment to the Jamaica Nationality Act, it states that the minister shall cause to be, currently states in the bill, that the minister shall cause to be furnished to the National Identification and Registration Authority in accordance with, this is on page 96. This is in the fourth schedule. So this is in the consequential amendments schedule. So there was
is asking how,
right.
how
Right, so,
the minister convey that information?
right, so that would be in regulations that would be prescribed. So the form and procedures would be prescribed under this act. But it's not a new insertion, it was there already. It's just that that particular declaration of renunciation of citizenship had not been captured. The only things that were captured were deprivation of citizenship and restoration of citizenship.
SG,
So the duty had already been.
Yes, understood. It's just that it means the form will have to be prescribed, and it's
Yeah.
the form is being prescribed under this law and not, it's not driven by the Minister of National Security.
Okay. All right. Thanks.
Through you, Chair, is it a concern, SG?
No, I
That
don't,
it's
not from perspective. I mean, it's more
Okay.
policy, but it's just that I would think that there needs to be consultation with the minister to ensure that what is being done by the authority under their regs is something that he can comply with. You don't want the authority to do something and they wouldn't have consulted the minister and ensure that it's feasible, or whatever they put in the form.
Right. So in other words,
There would need to be consultation with MNS.
when the form is being prepared.
Correct.
Right.
But that's
That would be
administrative.
the
That's
regulation.
administrative.
Okay. Thank you, SG.
All right, thanks, SG, and thanks, Amika. Back to recommendation, sorry, to clause 24, CPC would like to say something. Go ahead, CPC. Back to clause 24, it's on page 14. But CPC,
Yes, Chair, we had just discussed including something about legal professional privilege, but then when I went back and looked at what this provision actually did, it's the disclosure of identity information by the authority pursuant to a court order this out by the Commissioner of Police for the prevention, detection, or investigation of crime or in the interest of national security. So I'm not sure that the issue of any legal professional privilege would
I thought it was section 29 we were dealing with. So it's really section 29, not 24.
Yes, because that's a search provision.
Right. So we bear that in mind. Okay, section 29 deals with legal professional privilege. Okay, so colleagues,
Chair, just clarity, we do not need to refer to legal professional privilege. Act 24 is the agreement.
No problem. So bear now, we have agreed to those recommendations, including the final recommendation that the present bill, CPC, you will put in red all the changes in the various clauses, which will be attached to the report. And the report will have the recommendation that the bill will be withdrawn and hopefully a new bill will be tabled simultaneously. So colleagues, this basically is the end. What we're going to do is to ask Anila and Amika to finalize everything and send us the final report maybe today tomorrow. And we're hoping if everything, there are no further issues, that Anila, you can have members of the Senate sign on Friday. Is that possible, Anila?
Yes, sir.
Mr. Chairman,
Senator Montin.
This doesn't really affect the clause by clause review of the bill.
Right.
But in one of the opening meetings, I had asked if we, since government has generally been moving in a direction of merging and minimizing the number of statutory entities that we look at, if we couldn't have considered just as we have made the Registrar General one division of NERA, that we couldn't have looked at utilizing an existing entity like like PICA, for example, as the other division. And I know that is, in a sense, outside the scope of the bill because there was nothing in the bill about that. But wasn't there any ability to have a discussion around that at all from an efficiency point of view?
You mean to use speaker to do what Senator wanted to?
No, there were two divisions, I call it, of the NERA. There was the I think you refer to it as the civil division, where the one that would incorporate what is now the Registrar General.
Right.
And then the other division that would be more the issues around identity that we're talking about and the new cards and all that.
Right.
And I'd raise the question of whether from an efficiency point of view, just as we're, instead of duplicating the Registrar General, we have just provided for it to be taken under as a civil division, whether we couldn't have found a similar entity. And just throwing out, at the time I threw out, for example, the EOJ or the PICA to form the other division or to be incorporated into the other division. And to your credit, Mr. Chairman, you did take a piece of that on board when you used the ECJ as the inspectorate.
Now, may I just say, Senator Bunting, that it is being contemplated, you see, with the ECJ being a part, as came from a discussion you and I had, and then we discussed it with the Prime Minister, which he was very keen that it should be so. And when we spoke with the ECJ, they were also very happy to be a part of it. Now, we did discuss at one time, Senator Bunting, in one of the town hall meetings, the possibility that PICA, there could be strong cooperation with PICA. And Mr. Andrew Winter was with us at one of these town hall meetings. And the likelihood, as you put it, Senator Bunting, is that not immediately, but there could be a start in terms of the convergence of PICA with the NERA. But that we're not going any further than to intimate that, Senator Bunting. So what you're putting forward is something that was discussed at one of the town hall meetings.
Right, that was, but even before the town hall, I had raised it at one of the very early.
I recall that, yes.
Or it had been raised. But I was just wondering if, I know that it was part of the existing bill that was before the committee, but we had discussions, more general discussions than were limited to the clauses of the existing bill. And I wonder if in the report, there was going to be anything that touched on that.
I don't think we really had any recommendations during our deliberations, but you would want something in the report. Why don't we put it, leave it to the debate in Parliament?
Okay, all right, that's fine. But
that too in my debate, my presentation, and certainly you could raise it also in the Senate. Because
okay, no, I just wanted for the record that when we're debating it in Parliament and that is raised, people don't say, but why you didn't raise it in the, in the Joint Select Committee?
Chairman?
So I just wanted for the record.
Chairman?
Yes, AG.
The way to deal with it, if the committee agrees, is for a recommendation that consideration be given to, it can be formulated, the incorporation of PICA as part of the data registry. Someone else can do the recommendation, but I do agree with Member Bunting that in order for it to form a basis, even if it is not fleshed out, because it would require deeper policy consideration,
Right.
It could go as a recommendation, a consideration to be given to it.
That would satisfy me, Mr. Chairman.
Right. So what we could add this Kamika and Anila in the other recommendation. Just before the last recommendation, we put the passport and what is it? Passport and Immigration Act.
I'm sorry to interrupt you, Chairman, but
Yes,
I
Mark.
want to hear a comment from you before you proceed with the recommendation.
Yeah.
I just want to bring to the attention of the committee that currently there are a number of partnerships going on in the background to achieve what Member Bunting is recommending. For example, we have memorandum of understanding with Jamaica Post for the delivery of the system. We have a memorandum of understanding with eGov Jamaica, and we do have a memorandum of understanding that we are currently finalizing with PICA to utilize PICA's site to facilitate the enrollment of persons. So all those are being fleshed out, because the policy direction that we receive is that NIDS should not bring any additional burden on the state, but more so integrate as part of the existing ecosystem, which is what we have been doing.
Right.
So
Dr. Verna, all I was saying is that maybe we could look at a deeper integration in that particular, because there a lot of it seems to be overlapping. Where we were talking yesterday's meeting, for example, at the facial recognition software to avoid duplication that they already use and so on. And everybody who has a passport will basically also have the needs. So since one of the objectives upfront was stating we could reduce the numbers of these things, and the technology in passports is moving towards a digital type of document instead of the multi-page one we have. I'm just saying it's something that could be recommended for further consideration.
All right. I think you're right. Warren, could you put that last page, please, Anil? Nothing is wrong if you broaden it, Warren. Just a sentence to say the committee recommend further and great cooperation and integration with other bodies such as PICA, Jamaica Post, etc. Would that be satisfactory, Senator Bunting?
Well, I don't think the level of cooperation. Jamaica Post would be something closer to just an administrative.
Right.
But I thought of something more fundamental to be explored, to be considered. That's all.
So the committee recommends a greater integration with other public bodies.
Right.
Correction. The committee recommends the consideration.
Right. Recommends consideration. Recommends consideration rather than.
Yeah.
A greater integration with other
public bodies, such as PICA, for example.
Such as PICA. Because that will give us the opening to discuss it in.
Right. It's not making a decision one way or the other.
Right.
It's saying that we had considered it. It had come up in the course of discussion. And we think it's something that might be worth looking at from an efficiency, overall public sector efficiency point of view.
Right. At the end, could we put other acknowledgements? We need to indicate in the report that all the contributors' contributions are available in Parliament. Okay, so anyone would like to examine any of the contributions, they remain in Parliament, okay? And also, colleagues.
Maybe could you put like an exhibit or an attachment to just list contributions?
At the end, there is a list.
Oh, there is.
We have indicated, no, not there. We have indicated a list of.
Okay.
Right. And maybe we should say at the end that their contributions are available in Parliament.
Yeah.
Is that okay, Anila? What we don't want is we want anyone who would any sort of research being done by researchers to see how we got to this report, etc. Then they should be able to go back to all the contributors, and that will be available in Parliament.
That would be the Library of Parliament, Mr. Chairman.
Normally, from the persons are able to access any information that is tabled in the Parliament, submissions as well as the minutes and the reports and so on. So that is always available, sir.
Okay, wonderful. The other thing, colleagues, is that the Secretary, Anila, circulated the remaining minutes, and I suspect the minister yesterday and today will also be circulated. I'm going to ask that we confirm the minutes by round robin. Is that okay, colleagues? So that between now and next week, I'm going to ask that we do a round robin confirmation of the minutes. Okay? From here on, what we plan to do is to ask the secretary working with Jamaica and legal reform to just, I will also do read to make sure there are no corrections, further corrections to the report. And hopefully by Friday morning or Thursday night, any corrections, any concerns can be expressed. So that by Friday, Anila, a final report could be made available for the senators to sign on Friday. Is that okay?
Yes, sir.
And then
are we going to get a completed copy of the bill in addition to?
That is correct. I was just about to say, Senator Hill, we're going to ask CBC if she could, do the. I think I spoke to her yesterday in Parliament, CBC, and she said basically she's up to date, so she will just try to do a final list of all the amendments which could be attached to the report when it is circulated to us maybe by tomorrow, so that we can have a quick look on it tomorrow. So it can be signed off on Friday. And we're hoping that she will be able to send the final bill to the government printing office on Friday. And I speak to Mr. Thompson at the government printing office to see if at least the formatting can be done to be returned back to CPC on Monday, so she can check it before the final bill is ruled. Because that bill 2021, we're hoping to table in the House next week, Tuesday.
Chairman, I think we check the procedure in relation to withdrawal and resubmission of bill.
Oh, I know it.
In this proposed manner, I somehow believe, just permit us to check that procedure, please.
No, what happened? We have to do a resolution on Tuesday, AG, to withdraw the bill. So we'll do a resolution to withdraw the present bill, and then we table the next bill.
Still permit us to just make a check, Chairman.
No, sure, I will.
Handling of bills is a constitutional matter. I know we have developed some practices, but let us just check. Okay?
Sure.
I'd like to endorse that full, because that's why I'm asking for a completed copy before, because I know what happened the last time, and I really do want to go through every clause of this bill before it is passed. So I'd like to see a completed copy for myself and the notes that so I can cross-check them, because it's very
We're hoping, Senator Hill, that you can get that by tomorrow sometime.
Thank you very much, Chairman.
Wonderful. So if that is so, I would like to thank not only all the members for their active participation and the NIDS Secretariat at OPM, Law Reform, CPC who has been with us at the meeting, the SG and her department, the Parliamentary Secretariat, Anila, Grayson Morrison, Brendan Nash and all, the Public Broadcasting Corporation who has been with us throughout, and want to thank everyone who has been a part of the proceedings. So, colleagues, this we're hoping that when we table the bill, everyone will be able to sign, and we can have a fulsome report to Parliament and the Senate over the course of the next few weeks. So, if there are no other matters, I just would like us to sign off and thank everyone for their active and full participation in the Joint Select Committee considering the National Identification and Registration Act. So that means we ask for a motion for adjournment.
So moved, Chairman.
Thanks, everyone. I know.
Recording